Hello everyone, this is Komal Mathur, a legal intern at LEXIS and Company and a law student at Manipal University, Jaipur. Today we are going to discuss about Doctrine of Severability. So we will discuss what it is, where it came from and some cases related to it. So let us start. With the adoption of the Constitution of India in the year 1950, Part 3rd of the Indian Constitution also came into effect, which is known as fundamental rights. The fundamental rights are a set of inherent rights which guarantees every citizen of the country a dignified existence and a holistic all-round development. Any law that infringes upon these rights is liable to be struck down by the courts. Now the question however arises as to what happens when only a portion of the impugned law is violative of the fundamental rights, and it is in instances like this is what the doctrine of severability is invoked. Now the doctrine derives its validity from Article 13, which states, all laws in force in India before the commencement of the Constitution, insofar as they are inconsistent with the provisions of fundamental rights, shall to the extent of inconsistency be void. As an extension to Article 13, the doctrine states that when some particular provisions of the statute infringes or violates the fundamental rights, but the provision is severable from the rest of the statute, and then only that provision will be declared void by the courts and not the entire statute. Now the doctrine essentially lays down that if violative and non-violative provisions are separated in a way that the non-violative provision can exist without the violative provision, then the non-violative provision will be upheld as valid and enforceable. Now let us discuss about some cases which are related to doctrine of severability. One of the earliest instances of using this doctrine was the case of the Nordenfeldt versus Maxim Nordenfeldt Guns and Ammunition Company Limited, 1876. In this case, the court struck down the violative portion of a contract but held that the rest of the contract could go ahead after severing the violative portion. Now, the doctrine of severability was discussed at the length in the case of RMDC versus the state of Mumbai, and the court laid down the following principles. In order to find out whether the valid part of the statute can be separated from the invalid part, the intention of the legislature is the determining factor. In case the valid and non-valid parts of a particular statute are inseparable, then it will be invariably result in the invalidity of the entire statute. When the statute stands independently after the invalid portion is struck out, and then it will be upheld, notwithstanding that the rest of the statute has become unenforceable. In cases where the valid and invalid parts are separable but both of them were intended to be the part of the same scheme, then the whole scheme will be invalid. There may be instances where the valid and invalid parts are separable and not the part of the same scheme. However, invalidating the valid part leaves the rest too thin and truncated. Then also it will be invalidated as a whole. Severability is to be determined by reading the statute as a whole and not as specific provisions or parts. In order to find the legislative intent behind a statute, it will be legitimate to take into account the history, object and title, and also the preamble. In A.K. Gopalan versus State of Madras, the court found Section 14 of the Preventive Detention Act to be violative of the Article 14 of the Constitution. The court added that striking down the Section 14 will not change the object of the Act, and thus only impugned provision will be struck down and not the Act as the whole. A similar observation was made in D.S. Nakara versus Union of India. In the case of State of Bombay versus F.N. Balsara, it was held that violative provisions of Bombay Prohibition Act 1949 do not affect the validity of the entire Act, and thus there was no need to invalidate the statute altogether. Moving towards the conclusion, I would like to state that the doctrine of severability opens up the way for applicability of the judicial review. The courts through the judicial review invalidate the laws which infringe upon the fundamental rights of individual. When an individual contends that a particular legislation is taking away his or her fundamental rights and invokes the court's right to judicially review that decision, the burden of proof lies on him or her for proving how the impugned legislation has interfered with his or her rights. The doctrine of severability is a principle of great eminence in the Indian constitutional setup. It is a touchstone against which the validity of laws is tested. Now it is a check on the unfettered powers of the legislature, which if left to its own has the capability of going rogue and invading the very basic rights of individuals guaranteed by our constitution. So that's it for today. Thank you everyone. Have a nice day.